The Law Commission have recently issued a consultation on the law of wills, which hasn't been substantially reviewed since the Victorian age. Of course, there have been some state changes, but the substance is predominantly as it has been for many years. The motivation behind this is probably best summed up through quoting the words of Professor Nick Hopkins, who is one of the law commissioners, said, "Making a will and passing on your possessions after you've died should be straightforward. But the law is unclear, outdated, and could even be putting people off altogether. Even when it's obvious what someone wanted, if they haven't followed strict rules, courts can't act on it. And conditions which affect decision making, like dementia, aren't properly accounted for by the law." That's not right, and we want to overhaul to bring the law into the modern world. Our provisional proposals will not only clarify things, but will also help to give greater effect to people's last wishes. So that's encouraging. Just a modernisation of the law of wills to bring it up to date and to make it fit for this day and age. The Law Commission now proposes, and forgive me for reading again, but it's better to do that so I don't forget any bits, giving the court power to recognise a will in cases where the formality rules haven't been followed, but the will maker has made clear their intentions. So effectively, the sort of substance over form rule that's been adopted in so many of the tax avoiding cases I've been talking about over the last few years. An overhaul of the rules protecting those making a will from being unduly influenced by another person, really important part there. Applying the test of capacity in the Mental Capacity Act 2005 to the question of whether or not a person has the capacity to make a will. Providing statutory guidance for doctors and other professionals conducting an assessment of whether a person has the required mental capacity to make a will, and giving the Lord Chancellor power to make provisions for electronic wills, lowering the age at which people are able to make a will, quite important, this from age 18 to 16. That part about protecting people from fraud and or undue influence is a really important factor, I think, based on some of the cases we've seen recently. But the headline grabber has been the movement towards the possibility of having electronic wills. And in the days of proliferation, these days that is, of social media, that'll be quite interesting, so to see where that lands up, because you still need to have the right levels of proof and certainty around what a will is, but using appropriate media for the ways of expressing those wishes will be important and very, very interesting. So we'll wait to see the outcome of that consultation. Responses to the consultation are required by, I think, the 10th of November this year, and then we'll see the outcomes and we'll go from there. To take from this, however, those points is important, but for financial planners, perhaps the biggest point to take into account is that apparently there's only 40% of those over the age of majority have wills in this country. So it's a real opportunity, and has been for many years, for financial planners to be at the heart of that essential part of the process of transferring of wealth, to be at the heart of the intergenerational transfer of wealth that inevitably goes on and is so important to a financial planner looking to have a relationship with the family, not just their current clients, but their clients beyond them, their children. If they don't have a point of contact or are involved in that wealth transference process, it's going to be harder to make a link with the next generation. So perhaps almost inevitably working with other professional advisors, there's a real opportunity there for financial planners. Keep up to date with the developments on the consultation and the outcomes through Techlink. Of course, we'll be covering it in great detail in our bulletin section.